This is another episode in our interview with presidential candidate Abdul Hassan. Because Mr. Hassan is a naturalized American citizen, he's been challenging the Constitution's natural born provision in court. Presidential candidate Hassan has pioneered the argument that the natural born provision is irreconcilable with and is trumped, abrogated, and implicitly repealed by the Fifth and 14th Amendments. At the outset, Mr. Hassan, what is the natural born provision?
The natural born provision can be found in Article 2 of the Constitution, and it basically says that only a natural born citizen can be President of the United States.
Now, Mr. Hassan, you are a naturalized citizen. What's the difference between a natural born citizen and a naturalized citizen?
Well, a natural born citizen, as the name might imply, is someone who was born in the United States. And a naturalized citizen is someone who is born outside of the United States, but who has become a citizen through the naturalization process established by Congress.
How many naturalized citizens are there in America?
Based on the Census Bureau data, it's about more than 15 million naturalized American citizens.
I know it's a complicated issue, but give me a simple and brief summary of your arguments that the natural born provision has been trumped, abrogated, and implicitly repealed.
Well, the natural born provision discriminates against American citizens like me, naturalized citizens, because of our national origin. On the other hand, the Fifth Amendment, as interpreted by the highest court in the land, prohibits the very type of national origin discrimination. So right there, on one hand, you have the allowance of such discrimination, and you have the prohibition of the very type of discrimination by the Fifth Amendment, among other parts of the Constitution. So that's a conflict, and that conflict between discrimination and equality is irreconcilable. And we know it's irreconcilable because if the natural born provision or the clause was a statute, it would violate the Fifth Amendment, especially on the strict scrutiny analysis. Also, the Supreme Court of the United States, in a recent case, the McDonald case, which was decided in the year 2010, made it clear in addressing the conflict between constitutional discrimination and constitutional equality. The court said that such a conflict is irreconcilable. Now, when two parts of a law or two parts of the Constitution are irreconcilable, implicit repeal occurs because these two parts cannot coexist. Equality and discrimination cannot coexist, especially when we're dealing with what is called strict scrutiny type discrimination. So because they're irreconcilable and because implicit repeal occurs, based upon certain guidelines used to determine which provision will be trumped, the equality provision of the Fifth Amendment will trump, abrogate, and implicitly repeal the invidious national origin discrimination in the natural born clause. And we look at things such as the purpose of the Constitution, the whole intent and purpose, liberty, equality, the fact that our society is founded on equality, the fact that equality today is the public policy of the United States, as evidenced by statutes passed to that effect and so on. And also because of comparative value. Equality, as I said, is the foundation of our society, whereas the natural born clause was founded on the assumption that foreigners cannot be trusted. And the Supreme Court has said that such a rationale or assumption is legally impermissible and impossible to make. In other words, this assumption, and hence the natural born clause, really has no value, especially in modern day America.
Now, you're the first person to raise these implicit repeal arguments with respect to the natural born clause. Why do you think that is?
Well, in the first place, there are not that many naturalized citizens who have run for president, maybe because of this clause, but also because the interpretation of the Constitution upon which I rely in making my arguments has only been propounded recently by the highest court in the land, the Supreme Court of the United States. And let me give you an example. In 1857, the Fifth Amendment was interpreted to send an African person back to slavery or to keep him in slavery. The court reasoned that if he were to be freed, that would violate the property rights of his owner in violation of the Due Process Clause of the Fifth Amendment. In 1954, almost 100 years later, the interpretation was completely reversed, the interpretation of the Fifth Amendment. The court reasoned in 1954 in a case called Bowling versus Sharp that the Fifth Amendment prohibits the federal government from discriminating against citizens based on characteristics such as race, national origin, and so on. So that interpretation, which started in 1954 and which has become stronger and stronger since then, is very recent. So with the change in interpretation, the conflict between the equality guarantee and the discrimination in the natural born clause developed. And as you and I are talking here now, that conflict is irreconcilable, especially in light of the decision in 2010 in the McDonald case, which says that constitutional discrimination and constitutional equality are indeed irreconcilable, in which case equality will trump the discrimination.
What do you think about the so-called birther movement that are using the natural born clause to challenge President Obama and Senator John McCain when he was a presidential candidate?
Well, it's different from my situation in certain significant ways. The birther people are basically making factual allegations that President Obama was not born in the United States or is not a natural born citizen. Whereas in my situation, there is no dispute that I am not a natural born citizen. However, I do believe, one thing I do believe, and I know the birthers, many of them believe this as well. I share the view of the birthers that the Supreme Court of the United States should address the issue of the natural born clause and should do so soon.
When was the last time the U.S. Supreme Court addressed citizenship discrimination in the Constitution itself?
Well, the last time the Supreme Court addressed invidious citizenship discrimination that can be found in the Constitution itself was in a case called Dred Scott versus Sanford, which is one of the most famous cases in American history and American judicial history. In that case, the court unfortunately held that a person of African race or ancestry was prohibited by the Constitution from being an American citizen. And that case, some cite that case as one of the reasons for the American Civil War, which tore the country apart.
Dred Scott dealt with discrimination based on race and ancestry, and natural born clause deals with discrimination based on national origin. Is there a difference in the eyes of the law?
No. Under the modern jurisprudence, the modern interpretation of the equality guarantees in the Constitution, race and national origin are both subject to the same level of scrutiny. It's called strict scrutiny, meaning that any law that discriminates on the basis of race and national origin is presumed invalid unless the government can show there's a compelling interest and that the law is narrowly tailored to achieve that interest. So even though we're more familiar with race cases, national origin is given the same level of protection under the law as is race.
You mentioned modern constitutional jurisprudence. Has the Supreme Court upheld national origin discrimination in the last 60 years?
No. The last time the court upheld national origin discrimination was during World War II with the Japanese-American internment cases. And the Congress of the United States during the Reagan administration passed a law apologizing for those decisions and compensating the victims of those decisions, i.e. Japanese Americans. So the courts have made several mistakes, and either through congressional action or subsequent decisions, they've corrected those over the years.
How has the Supreme Court dealt with other significant discrimination cases in the nation's history?
Unfortunately, not so good. The court, I mentioned the Dred Scott case, the court has referred to its decision in Dred Scott as a great self-inflicted wound. In other words, they admit, and strongly so, that the decision in Dred Scott was wrong, that they were wrong to make that decision. Now, that is significant because if the court's decision in Dred Scott it was not right, and if it's because of the irreconcilability of slavery and equality, then that really helps my argument that today the discrimination in the natural born clause is irreconcilable with the equality guarantee of the Fifth Amendment and the citizenship clause of the 14th Amendment, and therefore the equality will trump the discrimination. Now, after Dred Scott, several decades after, the court in Plessy versus Ferguson once again upheld separate but equal or racial segregation as being constitutional. It took several decades after that for the court to admit once again that it made a huge judicial mistake in Brown versus the Board of Education. The court said separate but equal is no longer constitutional. During that same time, the court upheld the internment of Japanese Americans, which the Congress of the United States later apologized for and compensated those victims. So there's a pattern of the court making the wrong decision in significant discrimination cases like the one that I am bringing. And I would say to the court to break the trend, do not repeat the mistakes of the past, and stand up, do the right thing, and choose constitutional equality over discrimination.
And on that note, Mr. Hassan, thanks for answering the questions and good luck with your legal challenge to the natural born provision and in your campaign for the presidency of the United States.
Thank you.